So Daniel completed 6 months of probation without a single issue. Then he missed one appointment with his probation officer because of a work conflict. He assumed he could explain it at the next check-in, but 3 days later, he got a notice that a violation report had been filed and there was a hearing scheduled. What had been a closed chapter suddenly reopened. And if you're searching for what happened at a probation violation hearing in California, you need to understand that these hearings play by different rules than a criminal trial. And the stakes are very real. I'm Nana Knight. I'm a criminal defense attorney based in San Jose, California. And in this video, I will explain what triggers a violation, what the hearing looks like, and what options exist to fight it or minimize the damage, and what a lot of people actually miss that could actually help them. There are 2 types of probation violations in California. The first is a technical violation. That means you violated a condition of probation that was not itself a crime. For example, missing a meeting with your probation officer could be a technical violation, failing a drug test, not completing community service hours, testing positive for alcohol when your terms required abstinence, or failing to pay fines or restitution on schedule. These are all technical violations. The second is a substantive violation, sometimes called a new law violation. That means you were arrested or charged with a new criminal offense while you were on probation. And both types of violations can trigger a violation hearing, but they tend to play out a little differently. So technical violations often get resolved with modified probation terms, an extension, or some sort of a short-term custody or flash incarceration. Substantive violations are more serious because now you have a new case on top of your old one, and the court can treat both at the same time. What triggers this formal process? Usually it starts when a probation officer files a violation report. For technical violations, the probation officer has discretion. Not every minor issue becomes a formal violation. A good probation officer relationship and a history of compliance can sometimes prevent a minor issue from ever reaching a courtroom. But once the report is filed, a warrant could be issued for your arrest, or you may receive a notice to appear in court. At that point, you are looking at a probation violation hearing. And here's the most important thing to understand about that hearing. At a criminal trial, the prosecution must prove you committed an offense beyond a reasonable doubt. That is the highest standard in our legal system. At a probation violation hearing, the standard is preponderance of the evidence. That means the court just has to find it is more likely than not that you violated the terms of your probation. Think of it as more than 50%, like 51%. And that is a significantly lower bar than proving a case beyond a reasonable doubt. And there's no jury. A judge alone decides, and that does not mean you have no rights, however, right? So you still have the right to an attorney, you have the right to present evidence and witnesses, you have the right to challenge the evidence that's being presented against you as evidence of your probation violation. But you do not have the full procedural protections of a criminal trial, and the lower standard of proof means that the prosecution does not have to work as hard usually to get a finding of a violation by the judge. That's why talking or walking in without an attorney is a serious mistake, even if the violation seems minor. So what are the possible outcomes? The judge has several options after a violation hearing. First, the court can find no violation and basically reinstate you on probation on the same terms. This happens if the evidence does not meet the preponderance standard, or when there is a compelling documented explanation for what happened. Maybe you just wrote down the information wrong in terms of the probation or the meeting with your probation officer. Maybe you just had a clerical mistake. Second, the court can find a violation but modify the terms. This might mean extending your probation period, adding new conditions like additional classes or counseling, or requiring more frequent check-ins, or ordering community service. Third, the court can revoke your probation and impose a suspended sentence. This is the most serious outcome. When you were originally sentenced to probation, the judges usually suspend the jail term or the prison sentence with the understanding that you would comply. Basically, you're being placed on a grant of probation and you're expected to comply with all its terms and conditions. A violation could put that original sentence back on on the table as an option for the judge, right? Fourth, in some other cases, the court can impose a short county jail term. I often refer to this as flash incarceration as some sort of an intermediate sanction, and then release you back onto probation with some modification. So this is sometimes referred to as a short custody time, and the outcome depends heavily on your track record, the nature of the violation, and whether this is your first violation or your third or fourth or 10th, and how you present at the hearing, and critically, what your attorney argues on your behalf. So what can you do to fight it or basically limit or mitigate the damage? The most important thing you can do is to contact your attorney as soon as you know a violation report has been filed. Don't wait until the morning of the hearing. If you wait that long, basically, you've hurt your chances of being successful at the probation violation hearing. Your attorney will first look at whether the violation report is factually accurate, because mistakes do happen more than people think. Dates get confused. Sometimes a missed appointment, like I mentioned before, was actually rescheduled and documented as excused, and the paperwork did not catch up. Your attorney will also assess whether the evidence actually meets the preponderance standard, and just because a report was filed does not mean the court will automatically find the violation, even though the standard is low, right? Challenging the factual basis is a legitimate strategy. Also, your attorney can assess if the prosecution is going to try to introduce hearsay statements to prove up your violation. If that is the case, your attorney can object, because hearsay is not admissible at probation violation hearings. There has to be an exception for that hearsay evidence to be admissible. If the violation is not practically contestable, then the focus shifts to mitigation. That means showing the court that this was an isolated incident, that you've been otherwise compliant, you've done well on probation since you were granted the probationary term, and that you have already taken corrective rehabilitative steps. Documentation matters here, right? So proof of employment, letters from supervisors, family members, or counselors, evidence that you're enrolled in a program and attending, documentation showing restitution payments, proof that you've already done what the violation was about, even if you did it late. Courts pay close attention to whether someone is taking the situation seriously before they walk into the door. So proactive compliance is often the difference between a modification and a revocation. So what about Assembly Bill 1950 in California? California passed AB 1950, which significantly shortened the maximum probation period for most misdemeanors to 1 year and most felonies to 2 years. And this went into effect on January 1st, 2021. So if you're serving a probation sentence from before the law changed, your attorney may be able to use a violation hearing as an opportunity to argue the remaining probation period should be reduced. One important note, AB 1950 has major exceptions. So DUI probation, domestic violence probation, violent felony probation under Penal Code Section 667.5C, and certain other offenses carry specific minimum probation terms that are not shortened by this AB 1950. So an attorney needs to check the specific charge before relying on this argument. And for charges where it does apply, a violation hearing can sometimes result in a shorter overall term than what you were originally facing. So what happens if there's also a new criminal case? What do you do in that situation? If your probation violation is based on a new arrest, you are now dealing with two matters simultaneously: the violation hearing on the old case and a new criminal case on top of the old case that you were placed on probation for. These two matters interact in ways that can create serious complications. What you say in a probation hearing can potentially be used against you in the new case. So timing does matter, strategy matters, decisions made in the first case affect leverage in the second case. And this is exactly the situation where rushing to resolve one piece without thinking about the other case can create long-term problems that could be difficult to undo. So get your attorney involved before the first hearing on either matter. What happens at the actual hearing? The hearing moves quickly compared to a full trial, right? Remember, you're not entitled to a jury trial. The prosecution presents evidence of the violation, your attorney responds. You may or may not testify, so defer to your attorney on that, and that decision should be made very carefully. The judge typically issues a ruling at the hearing or within a very short period after. There's no waiting weeks for a jury to deliberate and come back with a verdict. If a violation is found, then sentencing can happen that same day, at the same time, or be scheduled for a later day, depending on the county where the case is at and the complexity of the case. So your case, when you're found in violation, could be set over for a probation violation sentencing at a future date. So come prepared, come with documentation, and come with your attorney. The short version of everything in this video. A probation violation is serious, but it is not automatically a disaster. The lower burden of proof means that the court does not need much to find a violation, but a well-prepared response makes a real difference. So show up with an attorney, show up with documentation, and do not assume that your compliance record will speak for itself without someone in the room advocating for you, making that argument clearly. And if you're facing a violation hearing, the time to act is now, not the morning of your court date. And if you or someone you know has dealt with a probation violation in California, I would love to hear about this and what county it was and how this was handled. Drop it in the comments below. I do check these comments. I read them. If you're facing a probation violation in San Jose, Palo Alto, Los Altos, or anywhere in Santa Clara County, do not go to that hearing without representation. You can call us if you want to consult with our lawyers at Night Law. Our phone number is 408-877-6177. You can also find resources and contact information on our website at nightjustice.com. And if you want to understand more about how the California criminal process works from arrest through sentencing, watch my other videos on this channel. What questions do you have about probation conditions or violation hearings? Drop them in the comments and I will do my best to review and answer.